Okay, good evening. Thank you for those of you who were in class for the last 3 hours. You're very good and kind to stay on for yet another, possibly an hour and a half, depending on how our debate goes. My name is Norah Gallagher. I'm currently the director of the School of International Arbitration. And for those of you who don't know, these co-curriculars is what they're called. They're meant to sit alongside our regular teaching, so our weekly teaching, and we usually try and pick topics and themes in international arbitration, whether it's investment or commercial, that are particularly relevant and we think that students ought to know. So it's meant to enhance the learning experience for students. As many of you know, when Professor Liu set up the School of International Arbitration way back when, almost 37 years ago now, he felt very strongly, he was the first person in the world to actually set up a school dedicated to teaching dispute resolution, but also felt that as it's a very practical skill, that we would teach the academic side, but also bring in experts in the field, which is what we have here today. So there'll be more of these events throughout the year. I also welcome to everybody online. Hopefully they're able to see and hear me from the very beginning, because obviously that will make it a little bit more interesting when the speakers start to present. So I'm delighted this evening to introduce Beata Gessel. I apologize if I get the pronunciation wrong. I had Polish, French neighbors, one of which was Pierre Zakrzewski, actually the photographer who was shot in Ukraine earlier this year. Anyway, so I've tried my best to get the pronunciation correct. She actually currently is a visiting fellow here at the school, so we're very pleased about that. Because not only is she a leading light in arbitration in Poland, she was the founder of Gessel law firm, and also is a professor at the Cardinal Stefan Woliński University in Warsaw. Beata is a very experienced practitioner. Actually, sorry, she's also a visiting fellow in Wilmerhale, scholar in residence, scholar in residence in Wilmerhale. I can't leave out that one because I'm sitting beside my former friend, maybe now, Steve Finizio. So she's been involved in over 150 cases, which, as you can imagine, when you're just starting out, that is quite a significant amount under all of the major international rules, and is very well placed to discuss what I consider to be quite a complicated topic. My substantive law and applicable law and I suppose maybe options for arbitrators in applying them is actually a very difficult and tricky area. So Beata has to be commended for choosing a very difficult topic right from the start. Professor Mistelis did say that probably this topic is something he cover in semester 2, but because Beata won't be with us in semester 2, we had to make use of her experience in the first semester, which is why we have Beata here this evening. And I will just hand over before saying just a very quick word about Stephen. I've known Stephen for over 20 years. He's an absolutely, really, again, super experienced lawyer, partner in Wilmerhale, excellent speaker, speaks even faster than I do, and I'm from Ireland, so I'm always grateful to be on a panel with Stephen because it makes me look as if I'm not skimming over my words. Yeah, and he's going to take an interesting, he's going to make a comment here and there, and obviously we both sit as arbitrators, we may have a slightly different approach or opinion to Beata, but that's actually really good for the debate, and then we throw it open to the floor, you can all have your comments. So on that, in order to save the time, and even if we do end early, the drinks are outside anyway, so we can discuss any outstanding issues at that point. So I'll hand over to Beata.
Good evening, everybody. I'm very happy to be here. And as Norah said, I'm here as a visiting academic, and I am very grateful for inviting me, and especially to Stavros Brekoulakis, who was the person with whom I have agreed the content of my visit and my research, and Remy Gerbin. I don't know whether Remy can hear me today, but thank you very much for being my guiding light in the realm of Queen Mary University. And let me tell you why I was. Let me start with saying why I was so busy with this topic. The topic is the how much the arbitrators should apply the applicable law. And prima facie, it appears to be a very simple thing, yes? If the arbitration agreement says the law applicable is English or Polish or French, it means that this is the law which will govern the case and the relationship. Well, I must say that my first concern was when I was when I was writing my previous book about declaratory relief, and I was trying to understand the legal interest. All of those who come from the civil law countries, jurisdictions, they know that this is the prerequisite for the declaratory relief. I was trying to understand how does it work in common law, how does it work in Germanic countries. Polish law belongs to this family of the Germanic jurisdictions. And the legal interest as a prerequisite to the declaratory relief is treated in many countries, in many jurisdictions, as the element of substantive law. And I have found that, especially I was interested in M&A dispute resolution, mergers and acquisitions, and I have checked around 20 awards, and I have found that this legal interest did not bother nor the arbitrators, nor the councils. And I was thinking, how come, if it is a substantive law element, how come the arbitrators can just go over this issue and not to apply? And this is when I finished that book, the declaratory relief, the concept of, the title is the concept complicated, the concept of the legal, real, and converged interest in declaratory relief. I started not immediately because I had to rest a little, and I started to think about how does it work in general. It means how come arbitrators does not need necessarily to apply this substantive law. And what I have found, I started, of course, with my domestic law. It means with my domestic law, it means Polish law, and I need help. No. Okay. I'll try both. Thank you very much. Okay, so I have started with my Polish jurisdiction, and I was trying to understand what is the attitude of the courts to this thing. So the first case you see here is that the court, all of these cases, what I'm showing right now, they are contemporaneous. That means they are all in the same era, I would say. So the first one says is that the arbitral tribunal is not bound both by the rules of the civil procedure, which is quite common in most of the jurisdictions, but also by the substantive law. I must, this is not very obvious opinion in Poland, and I think that this, I must make a footnote, because in 2006, Polish law has been changed into the model law system. And this Article 28, which says about application of the substantive law, came into life. And that's why, most of the opinions right now does not share this stance. But this is like a resemblance of the situation, which was quite obvious before change of the law. Before model law, Article 28 was introduced. It also shows how introduction of this article, which is normally neglected in learning and teaching of the model law, how it may change such as fundamental approach to the problem. Now the second one, the second one is said that the court says that the arbitration panel is not obliged to strictly apply the substantive law, but should be guided more than the courts by the principles of equity. So here we have like a more relaxed approach, saying that yes, you have to apply the substantive law. However, you can be more guided by the equity, by the moral principles, by something what we can name justice, it means fairness. And then we have another stance which says, and this is, I think, that the most popular stance right now, and I think the most popular under the model law jurisdictions, that it is not set whether the tribunal must apply or not the substantive law. However, if it does not apply, this is not the basis for annulment of the award. So you can say it has no teeth. It means that the substantive law, if there is a breach of substantive law, the award most probably will survive, but unless this breach of substantive law is elevated to the level of really big breach, it means this is a breach of public policy principles. This is additional point, which I think is quite important, especially in the practice of the arbitrators. What going on in case there is a number of interpretations or there is a leading interpretation in the court's jurisprudence. And then it says that we can have, with the arbitrators, we can have our own interpretation, and it, by definition, we don't have to follow the main line of interpretations in the courts. We can have our own, and I think this is quite important. That was Polish law wisdom. Now I tried to look into the international opinions, and I took for you some of the opinions which were given by the outstanding arbitrators. That was for me interesting. Article 1511 of the French Civil Code says that arbitrators takes into account in any case the trade usages. I was trying to search that. I think that we have here some experts on French law, so you can correct me if I'm wrong, but Desboissesson says that this is the main difference in France between the application of the law by the arbitrators and the judges, because the judges, they do not have this obligation to take into account the usages. So this is something what can differ in application of the substantive law, and arbitrators, they can. For me, this is a bit surprising, I must say, when I was thinking about this, because in most of the continental laws, this general clause about interpretation in accordance with the usages is built into the substantive law. So, regardless whether this is arbitrator or this is a judge, this kind of things, for example, Article 157 of the German Civil Code, it says, contracts are to be interpreted as required by good faith, taking customary practice into consideration. There is no change. There is arbitrator or the judges. This is just, in general, this is the same for both systems of decisions. Then we have Yves Derain, who says that the commercial arbitrators are most inclined to disengage from national laws in order to resort to general principles of law. And there is no question about amiable compositeur or some, equity judgments. This is here said about that in general, in international arbitration, there is such an attitude that we don't have to follow the applicable law because general principles of law should be sufficient. And contrary to this, what was said, there is the case of a French case, I think quite interesting, and the subject could be really discussed. That case was about deciding on interest. The contract said that the contractual level of interest was 10%. That time, the statutory level of interest was 2.27%. And the court what decided? The court decided, as we say, they wanted to split the baby, and they decided for 25. So they have decided less than sought by the claimant, but they decided more than it was at the level of statutory interest. And what has happened? The award has been annulled. Why? Not because of the misapplication of the substantive law, but generally non-application of the substantive law, because as it appears that time, maybe at least also now, the court, so also the arbitrators, as the court said, the court may only adjust the level of interest down to the level of statutory interest. So he cannot choose one of the other, something in between, as it has been done by this tribunal, but it must be or contractual or statutory. And we can, of course, discuss whether this is really misapplication of the law, of the substantive law, because I think that one can easily argue that based on the argument a maiori ad minus, that if somebody sought 10%, he also sought less than 10%, so for 25. But the court said that he cannot agree with this interpretation. At least I don't know really whether such interpretation was raised by the parties in this, but they said the arbitral tribunal did not follow the law applicable, but it departed entirely So it means that the court, they made a decision on equity. It means on amiable compositor basis. So they disregarded the law entirely. They were only guided by the principles of equity. You know, the flavor to this problem is also given by the fact that arbitration international is international. It means it has this cosmopolitan element. So there is a meeting of minds of people from different cultures. And such an example for you, this is the Philip Conogai, who was speaking about the differences between the cultures of Asia and the West. And he found something quite interesting. And if we have representatives of the Asian jurisdictions, I will be very happy to hear that there is a myth of applicable law for the contract, which applies to the contract in the Asia. That in Asia, the contract is growing, is developing throughout its implementation, and that due to the changes of the circumstances around and the relationship between the parties, it should be adjustable, like, technically, without looking whether this is in compliance or non in compliance with the given system of law. I think that, I was thinking whether this is really, also now, because as you see, this is quite aged article. So this is more than 2 decades which passed. And I'm just thinking about the globalization has made an impact on it already. It means that, like big career of cheeseburger, all around, that also the myth of the applicable law could make also the same career. But, I think that here my colleague will be more eligible to discuss having a lot of arbitrations in that region. And now coming back to Joshua Carlton, this is not so old, but it's also not very current. Joshua Carlton, he is the academic from Canada, and he was running such a project, and he was asking various arbitrators about their understanding of their role. He said that he made the 20 questionnaires, and because all of these answers were more or less the same or similar, he didn't continue his research with more of the representatives of the arbitration. But basically, what you see here is what these arbitrators in general, they said that for them, this is not only the applicable law, and even applicable law is something at the end of the process of making a decision, because for them, this is important. Economic situation as well, maybe not the most important, but they take into consideration what is the economic equilibrium between the parties, the fairness of the possible outcome, and what they say, that first they make a decision, what is right and what is wrong, and then they adjust their legal arguments. And at the end, this is the example of franchise lawyers who prepared a text, which is, I think, the most current, 2022. And they are representatives, what is, I think, interesting of this certain sector of the business. They are advising clients on franchise contracts. And they have found, and they were very disappointed that arbitrators, they do not stick to the law, to the black letter law, exactly. And they were expecting, and this is quite interesting because this is the expectation of the parties, that the arbitrators, they will apply the law exactly as the national courts do, because then it is predictable, and they can, as you see, they can better advise clients because they know what will be the outcome. Well, if you look into the book of the Jeffrey Wensheimer, he put together, many options. It means what could be what could we see as the expectations of the parties? Because finally, what is the most important? I think that the most important is really the expectations of the parties, but not expectations in the given case, because normally in the given case, claimant wants to win and respondent also wants to win, and then, they adjust their expectations to the given case. But this is something what we can say. This is the I think a lot of different expectations what we could face. Sometimes they are, as you see, contradictory, because on one hand there is a contradiction between the fairness based on equity versus the certain correctness or predictability. And by the way, I'm not sure whether this is really such a tension between these notions, because I think that they can be complementary to each other. But I think that one thing I would like to underline with the predictability, because it's very often used, the term predictability in the arbitration decisions. And I think that this is important to know what is predictability adjusted when. It means at what point are we talking about predictability in the predictability at the moment of signing the contract? It means then we speak about, we know what will be the outcome when the breach comes in, or we're talking about predictability at the moment when you are preparing the submission in the arbitration, because there is a different predictability. It means it is very often put emphasis on the fact that at the moment of signing the contract between different companies from different jurisdictions, they choose the applicable law in the very random way. It means they do not really make the deep, thorough analysis. What is the content of this law and what will have really the impact on their outcome? Sometimes it is really accidentally done. And they sometimes do not really presume that if the law will be applied strongly, means very correctly, that their contract might be asserted invalid. And I think that then this is very difficult to say that this is the expectations of the parties at the moment when they sign the contract. It can be expectation when they make a submission, but at the moment of the signing of the contract, usually, otherwise it is in bad faith. Usually they do not expect that their contract will be null and void. But you see, each approach might lead to the different solutions. If you want to have a correct, predictable solution based on the applicable law, then there will be different outcome if we think about equity, even if contrary to certain, I would not even say law, but contrary to the certain interpretations of law.
So I thought this would be a good point to interrupt.
Please do.
And draw some lines under the implications of what Beata just presented. And I guess I'm going to ask some questions. I want also people can ask questions as well at this point. Beata's got more to cover to go deeper into some of the issues that she's raised. But let's start with, is it right? The notion of discretion not to apply the applicable law, which is what we're really talking about, instead through fairness or equity, that sounds appealing, right? But can that possibly be what parties intend when they sign a contract that applies a certain law? And I've listened to Beata workshop this a bit and do research, and every time she does it, I have this very strong visceral reaction. It cannot be the case that we can say out loud, and let's come back to that out loud point, but that we can say out loud as an arbitration community that when we sign up to arbitration, what we're saying is the applicable law doesn't matter. And in fact, what we're doing is asking arbitrators to do fairness. And it can't be, even if that's what they do, and even if they can get away with doing that, and that's some of what I think we're going to come on to later, can it be right to say that that's what the parties expect and that's the right thing to do? And I think about it. I'm an American lawyer by training, and I often think about how do I compare international arbitration to domestic arbitration? And I will often say in the US, domestic arbitration is an ADR exercise, and international arbitration is not an ADR exercise. Because what you're doing in the US is something to solve a problem, and that's when we talk about speed, and when we talk about the rough justice babysitting. That's okay if you're signing up to an ADR exercise, but that's not what I think parties are doing when they sign up to international arbitration. So I don't think, my visceral reaction is it's not what we're empowering arbitrators to do. And frankly, when we have the choice to pick the governing law, and we want them to do justice or fairness or look at a broader scope, isn't the simple solution is for them to say we're doing this either ex aqua bono or amiable compositors, what we're looking for, or we're going to sign up for a lex mercatoria approach. But when they say English law governs, aren't we expecting, isn't their job to try their best, at least, to apply English law. And whether they can get it wrong and get away with it doesn't mean that's not what we expect. So that's my immediate visceral reaction. Then I realized, wait a second, let's think about what we do in arbitration as well. We have an appointment process where we're entitled to appoint whoever we choose. We can appoint a layperson, we can appoint an engineer, we can appoint a Swiss chair for an English law contract. Are we really expecting to get a finely tuned decision on English law when we appoint a Swiss chair? And isn't that in some ways license to say what we're doing is, and our expectations are that we're not going to get a strict application of the law? And then I interrogate myself again. I think, well, not getting a strict application doesn't mean we don't want someone to try to get an application that's right. I often find myself telling people that I think international arbitration is a comparative law exercise. And why do I say that? I say that because when you have a mixed tribunal in parties from different jurisdictions, when you're trying to persuade them, you often are thinking, okay, I've got this Swiss chair, English law. I need to figure out a way to describe English law in a way that will make sense to a Swiss lawyer. And I'm thinking about how do I communicate that. So again, I am sort of accepting when I do that the process is going to lead to results that isn't necessarily the same as you would get from an English judge when we have English law governing the contract. But does that mean it's licensed? And I think that the thing that still I come back to is A, judges don't always get it right either. B, is there something implicit in this whole discussion that suggests applying certain legal systems laws somehow is unfair? And then three, it's are we denying parties the fair opportunity to present their case if we're saying you can argue English law all you want, but the arbitrators may go off and decide the case based on other principles that neither side has expressly argued. Both sides presumably are arguing using an English law rubric in the way they describe their cases. And if they go off and then decide it based on fairness or trying to discern the intention of the parties through some broader understanding of what they must have meant, or in the Wainsheimer quote that was on there a minute or two ago, thinking about the overall relationship and what's right in the overall relationship, aren't they doing something that really is wrong? And when we come on to what happens in practice, when Beata comes on to that, I think we can keep coming back to this. But as I say, I end up finding this such an intriguing topic in part because what must be right isn't what happens. And does that make what happens right? And so I guess before you go on, or I don't know if you want to react to that or whether people in the audience want to react, because I think that's the implication. Let's take a step back. We can talk about it in sort of academic jargon about application of substantive law, but we're talking about really is, should arbitrators be allowed? And should our expectations be that they can do what they want, regardless of what the law says? Because I think that's the implication of some of where this goes. And I don't know whether you want to respond to anything I've raised.
A kind of a hypocrisy, what you propose. It means you will do like this, but we will not speak about this.
Well, that's okay. So exactly, we'll do this, and that's what the Joshua Carlton, which was a Queen Mary paper, I think, just to give Queen Mary credit. He sort of says what arbitrators tell you they actually do is figure out who wins first, and then draft a decision that gets to that outcome. Even if that's true, do we care? Do we want to say it's okay to do that, or we want to say you should be applying the law as best you can? I find this a troubling issue that as you press on it, and I think most of the people who investigate this will come out saying why this is not the right approach. Because if we say this is the right approach, aren't we delegitimizing international arbitration? And isn't the legitimacy of international arbitration a critical thing? So if I want fairness, I should pick Polish law or a legal system that looks, if I want to understand what the party's real intent was and not just the language of the contract, I shouldn't pick English law. And the fact that many people apply laws without understanding their implications, which Beata just said happens all the time, it is true. Does that mean they shouldn't be bound by their choice of law? And I think as we go through this, and I think it'll come up later as well, when we discern what parties intend in the arbitral process, as well as in the substantive outcome of the case, I think there's a whole host of interesting questions about what do we think parties really want when they choose this procedural thing, international arbitration, as well as when they choose the substantive thing, the choice of a particular legal system to apply to their contractual relationship. So that's my sort of interruption and my sort of flag to wave to say, look, this is a really, I think, a fundamentally interesting topic because it goes to the basics of what is this thing, this procedural thing we're doing, international arbitration. What is it? Is it an ADR exercise? Is it meant to be something else? And does what happens in reality make a difference to what we want to call it? I don't know. Yeah, so,
from my perspective, the whole basis of the international arbitration is microphone.
No, there's only a problem.
So, according to me, the whole basis of the international arbitration system is party autonomy. So, actually, for me, it should be the party's decision to choose the substantive law. And if they've already made a choice, an explicit choice, then the arbitrators must apply this substantive law to the dispute at hand. And parties can also choose lex marcatoria, and if that's their choice, then that's what's going to be applied. But if the parties haven't chosen lex marcatoria, because there's no explicit definition of lex marcatoria as well, so it's basically a set of rules which is undefined, so it might be unpredictable, the outcome I'm talking about. But if there's a substantive law choice and it's referring to a national law, and arbitrators just disregard that and apply lex marcatoria, then this is like the excess of power, so the decision can be annulled.
so I don't know whether Beata, you want to react to that. I will give you the reaction that as I work through my chain of reasoning, I agree with you until I get to the point of when you appoint a Swiss arbitrator to play English law, for example. If you aren't you automatically expecting there to be a certain looseness, or at least you're taking the risk? Is taking a risk the same as empowering? I don't know whether you want to.
Okay, this is a kind of introduction to my second part, I would say. So maybe you have an intervention.
I just wanted to bring up two articles. I think this is mostly from me coming from an international investment law background. I know it's a little different to this, but Article 42 of ICSID and I think 21 of Principle, they first give priority to the fact that the agreement between the parties should be taken, and only if there is no agreement should the tribunal then actually approve to something.
Yes, I think that this is pretty classic provision, which is, and in the provisions what you quoted, and in other provisions like I don't know, English Arbitration Act, in the model law, and I will come right now to this exactly point. So if I may, we were talking until now about expectations, about certain thoughts, about expectations of the arbitrators, about the expectations of the parties. I think that if I can make a summary, the general comment of myself, because I think that the expectations and the perception of this, the arbitrator's task has been changed within last 2 or 3 decades. If you see, the opinions and, the statements which are given by this, historical and legendary, arbitrators, like it was done here by Ibderan, that was, end of last century. And I think that this is a that was completely different approach than it is now. I think that there was an evolution of the opinions, and when I was trying to understand, or to find, the similar opinions which are given right now, it's really very difficult. If I find them, I will send you. But now, for me, it was really very difficult. I think especially that the basis for this change was the new Article 28 of the ancestral model law. I think it changed, the approach of the arbitrators and of the parties. And let me right now move to these procedural things. I was talking about expectations and what lesson, what consideration can be taken from these expectations. Now I'll be speaking about procedural laws and what comments we can, conclusions we can raise based on the procedural arbitration law. And at the end, I will move to the substance of the nature of the substantive law and how it impacts, the perception of the role of the arbitrator as well. So now the procedural law. I have made such a summary of in what limits we are moving around. If you are talking about procedural laws. So we have here like negative precept. This is public policy factor, the appeal on point of law, excess of powers, and then we have positive precept, which is this Article 46. If you're talking about this public policy factor, I think that we are all on this more or less on the same page. It means, what does it mean, the public policy? It means that we don't know what exactly means public policy. And this is very, general clause and undefined. And we can, usually it is, like identified based on case by case basis. And we can say that this is also in arbitral model law, in the New York Convention. So the award can be annulled based on the never on breach of substantive law, but it can be annulled if the substantive breach of substantive law is elevated to the level of public policy. It happens very rarely. And if you look into if you make research among the annulment of the awards, you will see that there is very rarely cases where the court is annulling the award based on some matters which are relating to substantive law. Mainly, this is such principles like pacta sunt servanda, proportionality, principle in case of compensatory measures, and the rules of good faith. I'm not talking about UK. I'm talking about the continent. So the breach of the good faith negotiation or good faith conduct. I must say that when I first met more closely with the English law and I found that principle of good faith does not exist here, I was very much surprised, and I was thinking, how come you can live, without this principle? But you can, So and pretty well. So this is one thing. This is this public policy. So so the substantive law is not what is the most important thing. Substantive law, breach of substantive law is not basis for annulment of the award. So let's go on. Article 28 of the model law, and this is, I think, 46 of the English Arbitration Act. Both articles, they say about this what my colleague here said, that the arbitral tribunal must apply the law which is chosen by the parties. Basically, we are here at the page where law is chosen. I'm not talking about the conflicts of interest and all of this bunch of problems. When it is chosen, and what does it mean? And yes, there is such a provision, and it changed a lot. For example, as I said, in Poland, because beforehand it was clear that arbitral tribunal can make judgments based on the equity, is not bound by the substantive law. Since 2006, it was a change. Model law was introduced, including the content of Article 28. And then it appeared new opinions about what is the role and what is the powers, what are the powers of the arbitrators I was showing you at the beginning. So when we are talking about this Article 28 of the model law, what does it mean? Prima facie, it is clear that the arbitral tribunal must follow the law. But what is really the power of this provision itself? And you will find at least 3 modes of interpretation. The first one says that this is a strict obligation, and as other persons said, this is the autonomy of the parties. It means autonomy of the parties. Parties has chosen the law. We must apply this law which is chosen by the parties. Otherwise, this is against the contract. The second way of interpretation is that this is so-called jus imperfectum. It means that there is an obligation, but this is more moral obligation because there is no sanction. Because if it was supposed to be so obligatory, then it would be the basis for the annulment of the award. And because it is not, it means that this is only moral principle, but not really the obligation. And the other argument is that there's no obligation at all, also based on this annulment procedure. So this is, you see, it can be interpreted, in at least in 3 ways, at least, because I think that we lawyers, we are very inventive and we can make some more interpretations. And then the third part, this is excess of powers. And I must say that this is the the least discussed issue. Maybe this is the future in front of it, you know. I know that the counter argument is the immunity of the arbitrators, but I think that it is going in this way, that, you know, that the arbitrators are more chaste than it was before. And basically, as for now, as I understand the current status in international turnover, there is not too many cases in which the court would say that there is an excess of powers. I think that this was the one of the cases was this French one could be really, you know, treated as the excess of powers, because the court said in this case, which I mentioned earlier, they said you exceeded the mandate, because you were supposed to judge based on law, and you judged based on the equity principles, because you did not apply strictly the law, because you had only two choices and you made third choice. So excess of power so far is not so much in use. I think that from the perspective of the continental lawyer, you know, this procedure which is in UK and in states where you can annul the law on point, the award on point of law, is quite interesting. And however, it is also for some consideration, because the idea is that in general you can appeal on point of law, but you can appeal. It happens quite rarely. When I was making my research, I asked my colleague to find out for me cases in which this appeal on point of law was run, and then I was said that Wilmerhale, there's none. Because why? Because, you know, you can opt out this possibility. Secondly, by rules of ICC, LCIA, so the biggest, you know, institutional arbitration institutions, this is opted out. So there is not many cases. Mainly this is shipping, and so there's not too much material. However, you can base, you know, jurisprudence can be also, you know, grow up based on these shipping cases, mainly shipping cases. I think that in general, also, if you are considering this appeal on point of law procedure, this is also very vague. So, like, I think most of the things around arbitration, because we have that the award can be abolished when it is obviously wrong, in most of the cases, and it can be abolished more simply when it is a standardized case. When there is a standard, so due to the good of public at large, it can be only open to serious doubt, merely open to serious doubt, and then this case can be changed, can be reformed, can be abolished, and, you know, generally can be done. So how much ambiguous is in this particular event terms, you know, what does it mean that the case is obviously wrong? And I think that you have seen it, but I think that none of these presentations can live without this quotation, that, you know, that what does it mean obviously wrong? You have to have a bottle of Chablis and the smoked salmon. So, and then you can simply, you know, this is the test. Okay. So if you haven't seen it, you have to see it, because this is everywhere quoted.
Pick up on this point
I only summarize, okay? Because I have also a question to you about this appeal on point of law, because I think this is quite interesting, this situation that you can opt out. What does it mean? But before I pose this question to you, I would like to say that all of these procedural rules, they should be understood and interpreted in the light of the paradigm of arbitration, because we have to see what Stephen said before, that there is a party autonomy which is pictured in the way how we appoint the arbitrator. We can appoint an arbitrator with free choice. Why do we appoint the arbitrator? We do not appoint him because of his legal skills, usually. We appoint him because of his reputation. If we appoint him because of the reputation, it means that we trust him. It means that there is really enormous trust, bearing in mind that there is no really second instance to check this award. So this is based on reputation. And Queen Mary in 2005 was running a research, a survey, where at least 5 criteria was asked the respondents. What is the main criteria important when you choose the arbitrator? The legal knowledge was, what do you think? Number what? From 1 to 5. 5. Legal knowledge was number 5. And you know, and the reputation was number 1. Yes, very good. You won the main prize. So that was important, this reputation. So if arbitration is based on this trust and based on our choice, it means that we have some trust in this, that the arbitrator, he will apply the law in the way as it is the best in his eyes. He will apply the law, the principles of law, whatever. I think that when we are choosing the arbitrator, and we know that he's more business-wise than, you know, legal-wise, you know, then we can expect what will be the result at the end. I must say, however, that this paradigm, I don't know whether it is not changing now. It means that was for ages, this paradigm. Yeah? When you call any of the treatises, you know, on arbitration, you will see this. You can go to Redfern, who says that 2 merchants choose one of their community whom they know and trusted, and they would abide by his decision without any recourse. But now, if you look into the recent text of Sophie Nappert, she speaks that there is a different situation now, that this paradigm might not work. It means we can discuss it, because this is, I think, very important and very fundamental question. She says that right now, for the millennials, the approval of anonymous peers in social media is more important than the decision of the arbitrator, individually appointed. And she makes, you know, the examples, the real examples, which right now exist, that in certain platforms, you know, the disputes are resolved in the way just like this. There is a statistical justice, I would say. This is like maybe it is, you know, perceived so positively as it was, you know, for ages, this individually named arbitrator. And I have a question to Steve, and you can right now pose your comments, but what is the value? You are living here. And what is the value? What argument can be derived from this fact if parties opt out the appeal on point of law? Does it mean that they grant somehow, you know, impliedly, the more freedom to relate, I would say, not apply, to relate to the applicable law?
Is opting out of Section 69 a license to get the law wrong is sort of the implication of this. And I think we started with this question of expectations. And I think superficially, it's appealing to say, well, the party choose English law, but maybe we don't think they really know what it means. They also opt out, so maybe they also don't really want English law applied. I'm not sure they're equivalent, though. I think people opt out of Section 69 ignorantly, sometimes a lot. I think it's a surprise to people from many jurisdictions that Section 69 exists. Now, if you come from the shipping world, it's very important to you. But if you're doing commercial stuff, Section 69 is actually often a surprise. But people don't even get to its existence because you're using institutional rules that mean they've opted out without knowing they've opted out. They only discover that they've opted out if a party, in the rare instances where a party might say, oh, there's Section 69, but we've used the LCIA rules, never mind, it doesn't apply. So I find it really difficult to read an intent into opting out, particularly through the mere choice of institutional rules, which de facto opt you out, as saying the parties therefore intended to give the arbitrators more license to get the law wrong. And certainly I've never heard that discussion happen. To the extent that parties opt out or talk about it, it almost always seems to be discussion around speed. You want a one instance proceeding. Now, obviously a one instance proceeding means you're taking more risk that the law is going to be done wrong, but I've never heard it that way. Now that's anecdotal. A lot of what we're looking at.
Me either. I'm just thinking.
So,
what does it mean?
we've got a comment here. We've got 2 comments. I want to make one quick other point, because you referred to 2005 Queen Mary survey, and and I don't have it at hand, but 2010, I think the Clean Merit Survey also asked parties what they wanted from arbitrators, and what good qualities and bad qualities were. And I wish I had it at hand, but one thing I always remember is, yes, knowledge of the law isn't particularly high on the list if it's on the list at all. And to be intriguing, fairness and open-mindedness is very high on the list, but I don't think fairness and open-mindedness means license to get the law or misapply the law in picking equity or fairness over the law. I think it means actually being non-biased and listening to the parties. I also think it's complicated to say that reputation means that we are discounting someone's reputation for getting the law right or wrong. But we have various people who want to pick up some of the audience.
So I have two comments. One is about the appeal of outside section. It's about the reputation and the ranking of reputation of college. Regarding the appeal of having just because it is a formal and oftentimes arbitration, one should expect activity in the case. So I think there could be so many reasons behind it that it's not safe to assume the intention. Also, in relation to the degree of importance between knowledge and reputation, I believe that arbitration is already something. This might be polemic, but
Everything is here polemic, in this topic.
Arbitrator lists are already filled with very distinguished individuals. The names that circulate along this when we're considering an arbitrator are not basic names. So I believe that knowledge of the law is an assumption, and therefore reputation and other considerations play a more important role, which does not mean that you don't want the rule of law to be applied.
Okay, so
I think it's a very good argument.
Yeah, it's knowledge of the law is an assumption, but what am I assuming about knowledge of the law when I appoint my Swiss arbitrator in the English law case? Am I assuming that they are people capable of understanding other legal systems, laws? I would say probably yes, but it's slightly more complicated if you're moving out. You're having arbitrators coming from different legal systems. I think.
I have another, if I may, just when you think about arbitration and litigation, and especially international commercial arbitration, catering to the purpose that it's business oriented, and in business you have to calculate risks. And I believe it all comes down to the moment of signing. If you need to calculate your risks for the future, and you choose a law, I believe you are choosing the written route because that enables you to calculate fairness will depend on the case by
Well, this is
case.
the predictability,
Yeah.
and certainty, and when in time do you care about it? That was the point she was raising earlier.
So at what date? At the signing the contract or when you write the submission?
Yeah, I think also addressing the issue of picking a Swiss arbitrator for the English law contract. I think what we are discussing.
Why always Swiss? This is
Polish arbitrator for the English law contract.
better.
American
American arbitrator. I would stick with Polish for obvious reasons. So I think there is one element that is missing in this discussion, because we are discussing the moment where the parties agree on substantive law in the contract, and we are talking about the moment where the arbitrators make a decision. However, I think the key dynamics here, also not only with respect to selecting the proper applicable law, which may or may not come from the contract, but also the interpretation of law, is the dynamics of the process and the submissions of the parties. Because actually, I think that the biggest problem, and of course I welcome your response to that, the biggest problem would be the parties argue certain law, certain obligations under a specific legal system, and then the arbitrator would go beyond what they argued and decide exec quod bono or under some made up rules. I think the key element is how the parties argue the case and how the parties formulate their understanding, their selection of applicable law in the contract and their interpretation of the law in a specific dispute.
So now we are coming into Uranovic Kuria.
Are you gonna pick this up later?
There will be something later on.
But to an extent, I agree that we are going to whether you can apply the law irrespective of parties' arguments.
Do I take one more comment, or do you want to move?
Yeah, please go ahead.
So I personally believe that, but still, the main purpose of this arbitration is to resolve. And if we are resolving it, then if you're trying to resolve it, I think that the ease should be at the parties, whether the parties should be given the opportunity at first or in the between, if both the parties agree also to change the law, then also I think it would be fair, because because of this restriction, the dispute continues, then I think that will be a huge loss for the commercial transactions. The company have to bear them. So I think that it's better to find a possible method which either way, applying the substantive laws or not applying the
So you're
substantive
taking the
laws.
Jeff Winsheimer, one of his questions.
One of
was-
the questions, because he
Yeah,
made all of
Yeah,
them.
lots of questions. One was, should you be thinking about the overall relationship, the ongoing impact?
I like your intervention because you are the only one who is, taking the opposite stance to anybody else who says that yes, this must be law applicable.
And let me, so let me be the opposite of you and say,
But
that
I
I am much more comfortable, and I'm willing to argue about this. And I think other people have said this, I'm much more comfortable holding the parties to their choice of law than I am, and reading the intention that is meant to apply, and then to be applied correctly as best possible. I keep putting those caveats on.
As typical lawyer.
Compared
Caveat to caveat.
to reading something into their opting out of Section 69 or generally their choice of arbitration, I'm much more uncomfortable saying we can read an intention to depart from the law into their procedural choices than I am into their substantive choice to pick the governing law. And I'm much more willing to hold them to this idea that they should have investigated the consequences of that, and particularly a passive act like accidentally opting out of Section 69, which many parties do. But that's debate, right? And I think I'm being very caveated now I say that, so it's obviously a hard one. And I think we need to keep moving, but part of it, we're having a discussion at the end in the middle, which is.
Okay, I would say that I am really, it means I really welcome, this opinion, because I think that there is the outset, there are many situations and each situation is different. And I thought that everybody is on the same page, with this opinion. And I thought that this is really weird, because normally when we have lawyers, each of them have a different opinion. So thank you very much for, supporting this, this classic stance. If before I move to the other part, I would like to also to respond to this, what Marek said. And I think that, it means on one hand, it touches the idea, the principle of Uranovic Kuria or not. It means whether the arbitrator can come out of the arguments which were raised by the parties or not. This is the issue which is usually debated within this principle, whether the arbitrator can raise a law which is not debated by the parties or not. But I think that there is also another point in this, what you were speaking about. It means that the parties debating the same system of law, Polish, and the arbitrator says, I don't like it, I don't like Eastern Europe. I will apply Swiss law because I am a Swiss arbitrator. So no, I'm really making this ridiculous, but in such situations when there is a real, and very straightforward departing from the system of law, then I think that this is also a pretty clear situation that there is the exceeding the mandate, But we are discussing more all of these gray zones. It means when there is no such a straightforward saying, no, I will not. I don't like you, I don't like your law, and I will do something different. So now it guides us to the last part. I was asking really with reason because I have no watch, so I don't know how much time do we have.
We have at least 20 minutes.
Okay, thank you. And because I was thinking about the because I was thinking about the nature of the law itself. So we are right now a little bit out of the situation that we have chosen one system, but I deliberately apply different system. I am right now in the situation that, yes, I do apply the system of law which has been chosen by the parties. So what conclusion can be taken from analyzes this substantive law as such, the nature of the substantive law? And the main question is how much we can say with certainty that the arbitrator departed from the substantive law. And, you know, I have here fantastic quotation of Herbert Hart, The Concept of Law. And I was thinking that we are so egoists, you know, we are so much looking into our side that I like it very much. It says that, you know, the substantive law is very much the subject of argument. This is discursive area of thinking. And he says, I find it interesting that medicine, doctors, they do not discuss what is medicine. And, you know, the chemists, they do not discuss what is chemistry. They just do it, you know, they practice it. And we, for ages, this is not our, you know, 21st century discovery, we are discussing for all along what the law is. And this is why we think about it also at this stage. We can speak and think about the nature of the substantive law, firstly, from this, what also already has been raised here, from this perspective of comparative law findings. So I like very much your, can you repeat what did you say? That this is the arbitration is comparative exercise, comparative law exercise. I think it's worth remembering. That was Professor Finizio. And this is why I say that, this comparative perspective is very important in understanding what is the nature of the substantive law. There are different ways of legal interpretation. And what was said in this very, you know, accused sentence of this anonymous arbitrator who said that I know what is right, I will find the way how to make the grounds for this right. There is a lot of different ways. There is an art of legal interpretation. And we are dealing with the situation. This is very often said that in common law lawyers, they are taking the declaration of will as it is. And we, it means because I belong rather to continental tradition, and we supposedly we are looking into the real intent of the action, of the declaration of will. And I think it's now blurred. It means when I am looking into the decisions, court decisions, English court decisions, and, you know, continental court decisions, I think that this is very much converged now. However, it is with the very big sympathy repeated by many arbitrators that we are different, you are different. You know? There is the international mix of legal cultures. Again, I can go back to this slide, which was speaking about the Asia tradition and the European tradition, which shows how essential, how fundamental can be differences in perception of this substantive law and the role of this substantive law. Then we have the issue of a layman. We also discussed this. If we say that we don't care, or we think that this is already in the reputational factor, but, you know, but certainly we can have, you know, the engineer who is not a reputable lawyer. He might not understand law at all. He might only understand the, you know, the architectural structures, and he is going to apply law in damages and so on. So I think this is important, that there is some understanding that this application of law is not such strict, does not necessarily be strict, because if I am a layman, then I don't have to understand, even if I am from the same legal culture, I don't necessarily will understand all of the subtleties of the different legal institutions. And all of it culminates in Uranovic curia and the problem of finding the law, because, you know, in some jurisdictions and some tribunals, they treat the law as a fact. The foreign law is not the law, but this is a fact, which is normally found and proved by the experts or codes or whatever, legal writings, you know. So if we treat this as a fact, it also gives a different perspective to this, how this substantive law is applied. And then this, by the way, if we're talking about the layman, I remember, and I think that this is very interesting in this context. There was a few years ago, there was a Swiss decision, quite described quite often, that there was an annulment procedures based on the fact that there was a sole arbitrator. He was not a lawyer, and he engaged the expert for himself, not the expert of the tribunal in the classic meaning. It means that there is an expert of the tribunal. Upon the expert comes and speaks, as an expert with the presence of the parties, and expert, like IBA guidelines expert appointed by the tribunal. That was like individual counsel for the arbitrator. And as I understood from this case, the expert was like, whispering to the ear of the sole arbitrator, what is wrong, what is right, especially in the procedure. But he could be also for the substance. And the annulment was not held. So basically, the institution of such an expert, legal expert, to the tribunal could be. So it means that also it gives like a different perspective for the fact of application of the law. And then finally, the discursive nature of the substantive law itself, like this art of legal interpretation. I would like to make a distinction between, and you have to understand it, that the substantive law itself has different mechanisms which allow for quite relaxed interpretation or various interpretation. And we have, I would say, like intuitive part of law and positive part of law. And this intuitive, this is this part of law which by itself, substantive law grants the possibility for the arbitrator or the judge to make decisions based on equity. And this is, for example, moderation of penalties. This is adjustment of the costs. These are decisions which are granted by the law, the equity decisions. Then there is a question, how much discretion has the arbitrator applying this part of law? There is a quite interesting case that was in Poland, and right now writing the article on it. So it says that the arbitrator in this decision, it is said that arbitrator does not necessarily must follow the interpretation and the criteria which are adopted by the courts in moderation of the penalties, because the court, the arbitral tribunal, is not a part of system of justice, of the state system of justice. They don't have to care about the inherent coherent system, that it must be, not contrary inside of it. So the arbitrators, they have much more flexibility in adjusting the contractual penalties. This is again for continental lawyers, because in UK there is no contractual penalties. And then, as I say, there's a question, what is the discretionary powers of arbitrators? I would suggest that quite a lot. So the criteria are not also something what is the basis for annulment. So if the arbitrator, this is my view, if the arbitrator adopted certain system of criteria, of values, and it adopted coherently, and it made grounds, like a logic understanding, how it is applied to the given state of facts, then the only system of criteria, the system of values which are proposed by the arbitrator, they shouldn't be subject to the change by the court. If it is internally non-coherent, contradictory to each other. So that I think that good faith is very important, and then I disregard this good faith in application to the given case, then this is something what is against, I would say, even public policy principle. And then we have other many questions, which are not to be answered. These are many questions. So this is, what is mandatory provision? What is the level of mandatoriness? We're discussing whether this is a proper word, and we decided that me, as the non-English speaker, I can say mandatoriness. So the level of mandatoriness, because we have the mandatory provisions creating the public policy in transnational sense. Mandatory provisions creating the public policy in national sense, for example, proportionality. mandatory provisions of law not creating public policy principle, non-mandatory rules of national law, the content of the civil law court's judgments or obiter dicta in UK law, trade usages, lex mercatoria. You know, it is not easy to find out which norm is what. It means how to classify the different norms into one of these categories. So what should be really followed? Then we have the problem, what are really the sources of law? In common law, for me, restatement is something mysterious, you know. For a continental lawyer to have a restatement, and I was trying to read that, I was trying to discuss with her. So, but what is this? It is obligated or not? So I can say that this is the source of law or not. This is like a statute or not. When I was, you know, reviewing the first time Dicey, the treatise, I was thinking, okay, but what is this rule? He says, rule 1, rule 52, rule 17, but where is it? And I was trying to understand where is this act upon which he is making comments. So that is really interesting for the continental lawyer. And the role of general clauses. You know, there are security mechanisms built into the system of substantive law. And they are security clauses, general clauses. They are based on usually good faith, on the moral principles. In the continent, in the UK law, we have the problem of the institution of estoppel. This is something what can cure the system of this black letter law, but is also rooted in the substantive law system. So if we change something, you know, we cannot. If we change, you know, the evaluation which is done by the substantive law itself, does not necessarily mean that this is the breach of substantive law. It might mean that we are using these general clauses in order to make more, in order to adjust these legal solutions to the particular situation. And finally, the law applicable in general. I thought that would be interesting for you, just to make you even more complicated. It is used to say that the arbitrator is a true guardian of the contract. If someone disagrees, raise your hand. So the true guardian of the contract. And there is the question of invalidity of the contractual stipulation, or the stipulation, or the entire contract. And the applicable law says that for some reasons the contract is invalid. And I have found at least 3 possibilities how the situation could be solved. One is that, which I found novelty, that when the parties are speaking in their contracts that there is certain system applicable to the contract, it means that this applicable law creates a part of the contract. There's a fragment of the contract. However, the contract rules over this system. So if there is something which is contradictory to the contract, this is the contract which rules, not the applicable law. The second one, which I think is more frequently, you know, proposed, that the law applicable governs the contract. So this is applicable to the contract. This is not the law, which is a part of the contract. And finally, I quite recently found such a, you know, really interesting interpretation that this can be the indication of a jurisdiction. How come, you ask? And I will answer. The case was about, you know, gross negligence. Gross negligence. The parties stipulate in their contract that they will not be liable for gross negligence. And this is usually, in most of the jurisdictions, against the mandatory laws. It means that you can make different autonomy of will, autonomy of the parties, covers all of the stipulations relating to the liability. You can exclude liability, save from gross negligence. And this is more or less, you know, most of the jurisdictions. So what was the concept? The concept was that in this situation, the tribunal has no jurisdiction on judging the gross negligence, whether the party is liable or not. It's simply the arbitration agreement does not encompass to these situations. I think great. I think it's very great novelty, and I really like this. Well, it means I don't say that I like the output, but I like the invention of the author. Okay, so in light of the above, I would say that we may posit and this is my question to you, do you agree with it? That it is very difficult to say, to apprise when the arbitrator really comes out of the realm of the given substantive law. That how come it can be made error, that he makes an error in the substantive law, if the nature of the substantive law is so much debatable, if it's so argumentative. I must say that I would like to give you at the end the example, the case study, short case study. And we have been running with Wilmerhale. I was running a project, a workshop with the interns together with Steve. This is why we are all together. So, so we were running a workshop in which we were discussing and preparing, you know, the presentations on moderation of the penalties as one of this intuitive part of the law. And within this workshop, I also gave them the case study, which I will tell you what is it about now. And the case was like this, that it is about invalidity of the contract. That there is a contract which has been signed by two entities. One, there is a consulting agreement, and the consultant is rendering services to his principal, and they have been cooperating for 2 years almost. The principal was issuing invoices, VAT invoices for this every month, let's say. And this, I don't know why Steve has escaped, you know, this is.
He knows the case.
He knows the case, but we usually quarrel about this case. And so there is this 2 years. After 2 years, the principal says that, sorry guys, but this contract is invalid because it required the authorization of the shareholders agreement. There was not such an authorization. This authorization is required not by the contract, but by the law, by commercial code. That this given contract, this type of contract can be authorized by the shareholders meeting, and that was not. So we had 2 years consulting. Services were rendered, nobody was claiming about the quality, and the claimant comes to the arbitration court and he asks to be paid back all of the values, all of the remunerations paid under these invoices as based on the unjust enrichment. Because the contract is valid, you have to give me back the money for 2 years. What do you think? Now we have, you know, we have to apply certain law, you know, and this law says precisely that the authorization makes renders the contract invalid. Do you think it's an easy case for the arbitrators? Thank you. Okay. What do you think? What do you think?
I think since there was no outcome, so I think into the question, I'm still not able to figure out the answer.
So, what do you think? That the contract is valid or invalid?
But
If you're the arbitrator, you would ascertain this valid or invalid?
I will declare it as invalid.
As invalid.
Yeah.
You would return all the money back to the.
Mhm.
So what about your fairness? You know, we were speaking about fairness earlier.
But that's the law says so.
Financial situation, you know. Yeah, Thomas.
I would say it's valid because there are
So this is very good because this is another
there are some customary usages in business, and when you have delivered 2 years of services, you cannot just come back on the contract and say, well, it was a null and void contract. Well, every business could do that.
Don't we expect?
Thomas is French,
Yeah,
you know,
but don't
he
we
knows that trade usages are for
But don't we
arbitrators.
expect whatever system of law there is to have some mechanism? So we're not, shouldn't we be able to get there through proper application of the law, rather than through ignoring the applicable law?
No.
If we have to ignore the applicable law, is there something wrong?
I'm sure there is something in the Polish law or whatever substantive law it
I
was.
didn't say this
That-
like Polish law. What
that allows you to get to that end result. I think if it's just 1 month difference, and maybe you can find out that the contract is void, but if it's 2 years, there must be something in the law. And just as a general comment for the first and second part, I think there are a few questions. First, why would you choose an arbitrator instead of a judge? I think an arbitrator has a certain sense of equity that the judge doesn't have. And if law firms would put as much money in judges as they would put in arbitrators.
Let's stop at that point. I'm not sure that's right. This is why I think the idea of thinking about why people choose it. A lot of people choose arbitrators because a lot of parties will choose arbitrators because they want to be outside of the courts of the other side's jurisdiction, and not because they think that an arbitrator is going to act differently, but they don't want to be in both courts of the other side. And a lot of parties increasingly are aware of the enforceability of arbitral awards compared to court judgments in an international context, not because they expect an arbitrator. You assume a conscious choice to say this is somebody who's going to do equity. I really want to challenge where that starting assumption comes from. It may be true for some parties, but can we assume that as a general approach? I don't know. I am very suspicious of that as what people think about, but that's a factual question that we should interrogate.
Just two arguments on this. So if you want the application proper, strict of the law, maybe choose a former judge as an arbitrator. And and a second, the circumstances of each case is different. Wait. Second argument. I'll be done.
Why do we assume judges get the law right? Why the very reason we have appeals is because we know judges don't get the law right.
Get the judge from the Court of Appeal then.
Well, they don't get it always right, and
Okay.
sometimes it gets reversed, or sometimes there's no other instance, and we live with bad decisions.
It's very true. But my second argument was the circumstances of each case depends, and in the end, it's about the relationship of the parties too. Some parties want revenge because their business relationship ended badly, and some others just want to resolve one specific issue but continue their relationship, and that's something that can be better dealt before an arbitration than a judge.
No, You're over here first. Sorry, I'm trying to accommodate everybody online. I only have one speaker for whatever reason. So we're also got a 5 minute. So we're gonna have to be quick.
Yeah, thank you. Well, I have two considerations. The first one is my concern regarding the decision-making process, because you asked for the question, and I think my gut and my background immediately leads me to a conclusion, and then I look for the possible arguments to support my position. So that I think may be a concern, because the applicable law maybe could be modified or applied just to support my conclusion, my preconceived conclusion. The second one was, I think the agreement would
So
be.
I have given enough argument. No, there is no arguments of the parties submitted.
Yeah, and
Yeah, I
it's.
agree. That was really, straightforward.
Yeah, and my conclusion is the agreement would be valid according. On the one hand, it's possible that the conduct of the parties makes the agreement valid. It's a formal requirement, the one that is missing there. So the agreement could be valid. And even if it's not valid, at the end, there's quite an equitable argument that is, why should the claimant be the one that is being receiving the final outcome? Like, he's going to receive the services, he's going to receive the payment. Why should I?
And this is not fair.
Yeah, and at the end, there would be an unfair enrichment from that party.
Hi, as quickly as possible, the answer to your case study. I think the arbitrator should decline jurisdiction. The contract is invalid, but the person has fairness before the court on unjust enrichment, which is an easier claim on these particular facts. You haven't said anything to the contrary. You can go to a national court, get a judgment on get judgment on unjust enrichment in this claim. So I don't think no jurisdiction.
Thank you. So my opinion is we do lack information, but I believe that somewhere in that law, there could also be something about reliance on appearances, unclean hands, good faith protecting reliance, unjust enrichment, customary and trade usages. So there are ways to apply the law, still achieve a fair outcome. If there aren't, as an arbitrator, I would just follow the law. The party shows it. I'm of that opinion.
Yes. Okay, so for my view, the arbitrator or the judge should just apply the law, and I would like to quote a Supreme Court decision, an English court. So it is not a place for the judge or arbitrator to twist the law, and if there's something wrong with the law, if not fair to the case at hand, then it is the duty of the legislator to make some adjustments, not the arbitrator.
Thank you. I think it is changeable country to country. I mean, from, for example, from Turkish law perspective, it is invalid contract because rule is a rule. So you can't do anything else. But in my opinion, it should be valid contract because parties desire going to arbitration. Because of that, they have signed an agreement. So we should check their bona fides, I think, their good faith. And it depends case to case and yeah.
I have only one last question. Last question. I would like you to raise your hand. Who thinks this is, who would judge this is invalid contract? Okay. Who would judge this is valid contract? Who did not vote? Okay. What is interesting that, sorry? Okay. What is interesting, is a really, really, very, very final comment, that, this is, as you could see, this is like 50-50, the share of the votes so there's like 50% of the prospective arbitrators who would go for the strict words of the law, and 50% who would go for more general fairness, moral principles, and another 50% who doesn't know. Thank you very much. Thank you.